Today we're discussing a case of the Supreme Court of India titled Kim Wansoo vs. State of Uttar Pradesh and another. Citation for the case is 2025 1 S.C.R. page number 1. The matter is a criminal appeal number 15 of 2025 and was decided on 2nd of January 2025 by Honorable Justices C.T. Ravikumar and Justice Sanjay Kumar. The issue for consideration in this case arose as regards invocation of the extraordinary power under Article 226 of the Constitution to quash criminal proceedings. A brief background of the case: it relates to the Constitution of India, Article 226, Code of Criminal Procedure, Section 482, pertaining to quashing of criminal proceedings, invocation of extraordinary power under Article 226, FIR registered under Section 406, 420, 323, 504, 506 and 120B of IPC against the accused, including the appellant-foreign national and project manager for defaulting in payment to the company. Appellant sought quashing of FIR. However, the High Court refused to quash the FIR. The correctness of that was challenged, and it was held that normally quashing of criminal proceedings would be sought and would be done in exercise of the inherent power of the High Court under Section 482. But that does not mean that it could not be done only in invocation of the extraordinary power under Article 226. The extraordinary power under Article 226 or the inherent power under Section 482 could be exercised by the High Court either to prevent abuse of process of any court or otherwise to secure the ends of justice. On facts, the High Court erred in refusing to exercise the extraordinary power under Article 226 to quash the FIR and all further proceedings in pursuance thereof, qua the appellant. Perusal of the FIR would reveal that the same did not disclose commission of offence as alleged without anything being added to the recitals thereof. Besides the vague allegations, the rest of them, even if taken as true, would not disclose the commission of any offence and make out a case against the appellant. In such circumstances, asking the appellant to stand the trial would be nothing but an abuse of the process of law. As such, non-interference by refusal to exercise the power to quash the FIR and further proceedings based thereon would result in miscarriage of justice. Judgment passed by the High Court set aside FIR and all further proceedings pursuant thereto qua the appellants quashed and set aside. Case law cited: State of Haryana and others versus Bhajanlal and others, Pepsi Food Limited and another versus Special Judicial Magistrate and others, Eastern SPG Mills versus Rajiv Podar, State of Andhra Pradesh versus Golconda Linga Swamy, Muhammad Wajid and another versus the State of UP and another. The judgment, as dictated by Honorable Justice C.T. Ravikumar. Leave granted. This appeal by special leave is directed against the judgment dated 26th of August 2020 in Criminal Miscellaneous Writ Petition number 8063 of 2020 passed by the High Court of Judicature at Allahabad, refusing to quash FIR number 64 of 2020 registered at Police Station Sadar Bazar, District Meerut. Furthermore, it was ordered thereunder thus, in quotes, however, considering the allegations made in the FIR, the provisions of Section 157 CRPC, and the view taken by the Apex Court in the case of Joginder Kumar vs. State of UP 1994, it is directed that the petitioner shall not be arrested in the above case till the credible evidence is not available against him during the investigation or till the submission of the police report under Section 173(2) CRPC, whichever is earlier. Quotes end. On 14th of October 2020, this court issued notice and also stayed further proceedings based on the subject FIR. The said order is still in force. The facts leading to the impugned judgment read as under. Hyundai Motor India Limited, for brevity HMIL only, awarded a contract for construction and development of a project work, namely Gurgaon HMI Project RC Works, hereafter referred to as the project, at Hyundai Engineering and Construction Limited LLP, for short HEC India LLP, Agreement dated 20th of October 2017 was executed therefore between the said companies, and the appellant herein was the project manager of HEC India LLP. He is a foreign national. HEC India LLP subcontracted the work to Kotak Automotive Services India Private Limited, for short Kotak, which in turn subcontracted the RC Constructions work to Messrs. YSSS India Construction, for short YSSS, and YSSS further subcontracted with Messrs. RT Construction, which is the complainant's respondent number 4 herein, entity, to obtain manpower. It is alleged in the subject FIR that YSSS, in connivance with other accused, defaulted payment to the complainant's company. The subject FIR was registered under Section 406, 420, 323, 504, 506, and 120B of the Indian Penal Code 1860, hereafter the IPC, against the accused, including the appellant herein, on the allegation that YSSS, in connivance with the other accused, defaulted payment to the company to the tune of Rs 9 crores pursuant to the lodgment of the FIR. The appellant received notices dated nil on 6th of August 2020 and 9th of September 2020, issued under Section 91 of the Code of Criminal Procedure 1973, hereafter the CRPC, calling upon him to produce certain documents. Though the appellant produced the documents in his possession before the investigating officer, he got further notices insisting for production of more documents which, according to him, are not in his possession. It is in the aforesaid circumstances and raising various contentions that the appellant approached the High Court seeking quashment of the FIR, which is produced in these proceedings as Annexure of P9. Multifarious contentions have been raised unsuccessfully by the appellant to support his prayer for quashment of the subject FIR before the High Court. He reiterated such contentions before us as well. But before dealing with such contentions as also the challenge against the impugned judgment, it is only apposite to refer to the relevant recitals from the subject FIR, which reads as follows. In quote, about all aforementioned people conniving with intention to cause loss to the applicant and to make gain for themselves, hatching criminal conspiracy, committing cheating, fraud, and forgery against the applicant, and misappropriating applicant money. Honorable Sir, this is to submit that applicant Tahir, partner Messrs. RT Construction 202B9, ground floor, Thatwari Complex, West Road near Meerut Public School, Meerut, has been doing business from a long time. The applicant has been doing business of construction for approximately the last 30 years. The applicant's brother Nasir and partner Ravindra to look after the said business along with the applicant. Applicant has been providing various services in construction, including providing services of skilled and unskilled laborers to other companies. Aforementioned number 6, Siweng Hui, Hair, Managing Director, Yu Sweng Sang Sa India Construction Private Limited, YSSS, which is a subsidiary company of the main company Messrs. Hyundai Motor India Group, had issued a work order to the applicant on 15th June 2018 because the applicant has been providing laborers to Korean company for a long time. Therefore, on basis of the applicant's goodwill, aforementioned people sent work order on applicant's mail ID, photocopy of which was sent to the applicant at BIS House at Meerut by the aforementioned person through their employee. Applicant finalized final rates after discussing with all aforementioned persons, and after the officers of aforementioned company agreed to it, contract was drafted in Meerut and work was assigned. Applicant's company provided laborers as per requirements of the aforementioned company from August 2018 till 2019, for which the applicant made bills on time and gave to the aforementioned persons. The bill was to the tune of approximately Rs 9 crores, of which the aforementioned company paid Rs 1 crore 70 lakh 51,000 to the applicant from time to time. Thereafter, while misleading the applicant, additional work to the tune of Rs 8 crores 31 lakh 94,200 was done. The applicant gave good performance because the applicant felt that it was a foreign company and India should not be maligned. After the work was completed, Messrs. YSSS issued checks of approximately rupees 8 crores 31 lakh 94,200 in favor of the applicant's partnership firm, all of which were dishonored. The applicant complained to Messrs. Hyundai Motor India, which is the main company on which Messrs. YSSS was summoned, and a reconciliation was made not to file any case. And now our other company, Messrs. Kotak Automotive Service India Private Limited, shall make the payment to you because Messrs. YSSS had largest liability towards the applicant, which was to the tune of approximately rupees 8 crores 31 lakhs 94,200. Aforementioned company, Messrs. Hyundai Motor India, settled payments of 16 persons along with the applicant, and while accepting its responsibility, nominated Messrs. Khan Autic Automotive Services India Private Limited, which is a part of the aforementioned company, to handle monies. Officers of aforementioned company agreed that now payment of only rupees 7 crores 67 lakh 30,826 shall be done to applicant, to which the applicant agreed. Of this, 40% payment was to be done by the aforementioned company immediately, and the remaining payment was to be made after 2 months. Officers of the aforementioned company reduced this reconciliation in writing and gave a copy of it to the applicant, and also gave two checks of rupees 61 lakh 38,446 and rupees 2 crores 45 lakhs 53,864 on 30th of November 2019, of which check of rupees 61 lakhs 38,446 was encashed, and the remaining check of rupees 2 crores 45 lakhs 53,864 was dishonored. Applicant and applicant's brother Nasir went to the office of the aforementioned persons on 3rd of October 2019 to demand payment, but the aforementioned persons misbehaved with the applicant, his brother and partner Ravikumar, subjected them to obscenities, and issued threat to kill them if they went there again. Also, there was no reply to several phone calls made. Applicant's brother Nasir Ali Khan kept on visiting the office of aforementioned persons for remaining amount, but the aforementioned persons did not give any money to the applicant and his brother Nasir Ali Khan. Instead, on last visit to the office, the aforementioned persons assaulted and abused the applicant's brother, as a result of which the applicant's brother suffered serious trauma, and because of which applicant's brother Nasir Ali Khan passed away on 30th of January 2020. Applicant has proof of acts of aforementioned persons in the form of documents in his safe custody, all of which are enclosed in the application. All above mentioned persons have indulged in criminal conspiracy and forged documents through their company to commit cheating, fraud, and misappropriation against the applicant and other persons. Applicant has lodged complaint in aforementioned matter at Sadar Bazar police station, but no action has been taken till this date. Therefore, request is being made to Honorable Sir to kindly order officer in charge of Sadar Bazar police station to register case against the aforementioned persons under aforementioned sections and take stringent legal action against them, and to help the applicant to recover aforementioned amount from the aforementioned persons. It is worthwhile to refer to some of the decisions of this court in regard to the power of the High Court to quash criminal proceedings before considering the rival contentions with reference to the allegations made in the subject FIR as extracted above. It is true that normally quashing of criminal proceedings would be sought and would be done in exercise of the inherent power of the High Court under Section 482 CRPC, but certainly that does not mean that it could not be done only on invocation of the extraordinary power under Article 226 of the Constitution of India. This position was made clear by this court in the state of Haryana and others versus Bhajanlal and others. After considering the statutory provisions of CRPC and the earlier decisions of this court, in the said decision, this court held that in the following categories of cases, extraordinary power under Article 226 or the inherent power under Section 482 CRPC could be exercised by the High Court either to prevent abuse of process of any court or otherwise to secure the ends of justice. This court went on to observe and hold that it might not be possible to lay down any precise, clearly defined, and sufficiently channelized and inflexible guidelines or rigid formula and exhaustive list of myriad kinds of cases wherein such power should be exercised, and encapsulated the following cases falling under such categories. In quotes, paragraph number 102. In the backdrop of the interpretation of various relevant provisions of the Code under Chapter 14 of the Principles of Law enunciated by this Court in a series of decisions relating to the exercise of extraordinary power under Article 226 or the inherent powers under Section 482 of the Code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of process of any court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. First, where the allegations made in the first information report or the complaint, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Second, where the allegations in the first information report and other materials, if any, accompanied by the FIR do not disclose a cognizable offense, justifying an investigation by the police officers under Section 156(1) of the Code, except under an order of the magistrate within the purview of Section 155(2) of the Code. Third, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of an offense and make out a case against the accused. Fourth, where the allegations in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of the magistrate as contemplated under Section 155(2) of the Code. Fifth, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Sixth, where there is an express legal bar engrafted in any of the provisions of the Code and the concerned Act under which the criminal proceeding is instituted, to the institution and the continuation of the proceedings, and or where there is a specific provision in the Code or the concerned Act providing efficacious redress to the grievance of the aggrieved party. Seventh, where a criminal proceeding is manifestly attended with malified and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Inverted commas close. The said position was reiterated by this court in Pepsi Foods Limited and another versus Special Judicial Magistrate and others. This court held therein that the High Court could exercise its power of judicial review in criminal matters and it could exercise its power either under Article 226 of the Constitution or under Section 482 CRPC to prevent abuse of the process of the court or to secure the ends of justice. Furthermore, it was held that exercise of that power would depend upon the facts and circumstances of each case. In regard to quashing of criminal proceedings at the investigation stage itself, this court in Eastern SPG Mills versus Rajiv Podar held that the High Court could interfere with the investigation if non-interference would result in miscarriage of justice. In State of Andhra Pradesh versus Golconda Lingaswamy, this court again held that where an FIR did not disclose the commission of an offence without anything being added or subtracted from the recitals thereof, the said FIR could be quashed. We have already extracted the relevant recitals of the subject FIR despite a microscopic examination of the allegations raised thereunder. Except some vague allegations, no specific allegations could be seen made against the appellant herein or against the company by the name HEC India LLP, wherein he was the project manager. That apart, a scanning of the subject FIR would reveal that after making some allegations, the complainant was the fourth respondent herein sought for registration of a case against the persons named therein, including the appellant herein, to help the complainant appellant herein to recover the amount mentioned therein. In this context, it is to be seen that the allegations therein would reveal that the complainant committing default in payment of an amount of around ₹9 crores was not made against the appellant herein or against the company in which he was project manager, whereas it was made against a different companies. In the contextual situation, it would also be relevant to refer to the decision of this court in Muhammad Wajid and another versus State of UP and another, wherein this court, insofar as it is relevant, held thus, inverted commas, paragraph 34. It will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under Section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation, registration of the case as well as the materials collected in the course of the investigation, inverted commas close. On judging the case on hand with reference to the allegations extracted herein above, in the light of the decisions referred supra, we have absolutely no hesitation to hold that the High Court clearly erred in refusing to exercise the extraordinary power under Article 226 of the Constitution of India to quash the subject FIR number 64 of 2020 and all further proceedings in pursuance thereof qua the appearance. A perusal of the subject FIR would reveal that the same did not disclose commission of offence as alleged without anything being added to the recitals thereof. That apart, besides the vague allegations, the rest of them, even if taken as true, would not disclose the commission of any offence and make out a case against the appellant. In such circumstances, asking the appellant to stand the trial will be nothing but an abuse of the process of law, and as such, non-interference by refusing to exercise the power to quash the FIR and further proceedings based thereon would result in miscarriage of justice. In such circumstances, this appeal is liable to be allowed, and resultantly it is allowed, and the judgment dated 26th of August 2020 in Criminal Miscellaneous Writ Petition number 8063 of 2020 is set aside as a necessary sequel. The subject FIR number 64 of 2020 registered at Police Station Sadar Bazar District Meerut, and all further proceedings pursuant thereto, qua the appellant, stand quashed and set aside. Pending applications, if any, shall stand disposed of. Result of the case, appeal allowed.